We are here for PCC and bond violation. I understand the court has received and reviewed the materials that were sent over yesterday.
I did.
Thank you, Your Honor. The only request that we would have when we're discussing those materials, she is staying in a shelter in Livingston County. There is a separate DB having nothing to do with any of this, and there are some cross allegations in that case. So she's just requesting that we not say the name of the shelter if someone is listening on Zoom to where she's staying.
Understood.
Thank you, Your Honor. I believe that the materials that we provided were pretty thorough in terms of where Ms. Brown has been coming from and what her circumstances are in pertaining to the bond violation. So I was wondering if the court had any questions.
Well, I do, because I'm not sure how you provided the materials, but I'm not sure how that relates to the specific allegations of the bond violation.
You can feel the tension early on. The court's not playing today. They've reviewed the evidence, and now it's time to answer for violations. But this isn't just about breaking rules. This is about trust, structure, and the consequences that follow.
You can explain to him where you're at in terms of the allegation of I had forwarded her the reports the same day. And just so that Your Honor knows, she did intend to turn herself into the jail this morning, but she was unable to get a ride this morning. And so she's here for in-person court this afternoon. So regarding the tamper on 6/23 and then the positive on 6/25, the court is looking for either an explanation or an admission as to these two.
Your Honor, I don't have any clue why those were coming up that way. I know that I was called in to community corrections to have my unit replaced for servicing. And when on my way there, Miss Julian called me and said that she received a notification from courts that I had a tampering and violation that she would, wanted clarification about. And I had no idea what she was talking about. I told her that I was just called in to do a replacement on the unit itself. I have only been at La Casa AA meetings and with AA people because I don't currently have transportation and a license to get myself to and from these places. And I have not had access or been in the environments of drinking whatsoever. The only events outside of AA are AA events that I've been to, such as there was a sober rave in Royal Oak that I'd gone to, but that wasn't even in the dates in question.
Miss Brown starts explaining, but notice how scattered it is. She talks about servicing the device, AA meetings, a sober rave, but not once does she directly say, I didn't do it. That vagueness? That's a red flag in court. Judges want clarity, not confusion.
So I'll stop with that. But I was completely confused. So I had the unit replaced. And while at community corrections, they had told me that I had this tampering and violation 2 counts. And I was in for my reading the week before during this time. And they said that I was all set, good to go. We'll see you next week. And so I was really unsure why I was getting that unless it was due to needing servicing.
Now this part is heartbreaking. She's saying she was locked in the shelter with no access to alcohol, and she's basically begging the judge to believe her. Whether or not she's telling the truth, this is where her life circumstances and legal obligations collide hard.
But I have not saying, Your Honor, this is way too important.
Well, hold on a second. Just so that we're clear before you go on with your story.
Okay.
On June 23rd at the 12:56 a.m. time.
Yes, sir.
That's when the tamper is detected.
Okay.
With the unit. On the 25th, there isn't a tamper. It's just drinking.
I don't know why it's coming up with that unless the servicing part of it needed it. At the shelter where I'm currently residing, there's a locked door policy from 11:30 p.m. until 7 in the morning. And I didn't have access any of those days to alcohol or have them in my possession at a no drinking facility. And I was at the facility at both of those times, documented on camera. I believe they have at the shelter as well as my sign in and out sheet.
This is where the judge hits his breaking point. He's frustrated, not just by the missed surrender, but by the pattern. No shows, no communication. The court doesn't like being misled, and Miss Brown's credibility just took a major hit.
Not just the violation reports, but if she's been indicating, and she did to me that day, that they called her two community corrections switch out her unit. If there was a problem, and this would have been the unit that was switched out. After this, this would have been the problem unit, is what I'm saying, is that if there was a problem with the unit. So perhaps we hearing where community corrections can bring their documentation of what they did and when, and the servicing of their units.
How much time would the people need?
I'm emailing community corrections right now, and time that works for the courts, I can bring one of them over. Anytime that works for the courts, I can bring one of them over for a bond violation hearing, whatever the court.
All right, I'll set it for August. I'll set the bond violation hearing as well as adjourn it. This time the PCC out to August 1st, 2024. Actually, it's going to be at 3 p.m. because I got to be a hearing.
That final hammer drop? Brutal, but expected. She had so many chances to follow through, and instead the court feels like she made her own rules. When the judge says, you don't get to make those choices, you can feel the frustration of a system that's run out of patience.
I understand, Your Honor. I informed Ms. Brown of that the same day that the court issued the warrant. I did instruct her to turn herself into the jail. I do believe that part toward the end of her letter that was directed to the court expresses that she was emotionally really grappling with coming into custody based on all of her circumstances that were outlined. I have continued to encourage her to turn herself into the jail. She was going to do so this morning, but she does not drive.
And Ms. Julian, and I'll just tell you, that's part of my problem. Part of my problem is I know how you operate, Ms. Julian. You told your client, tell them what the right thing to do is, and they don't do it. And today, or yesterday when we received the information and we understood she was going to turn herself in that morning, and so we were then trying to make sure that she was going to be on the docket at the proper time so we'd see her. So she was just sitting there and she doesn't turn herself in. And my staff, we're going all around trying to figure out where she is. And then I get an excuse she doesn't have a ride here. I just don't think she's going to do what anybody asked her to do. She's just going to make her own call on all this stuff. And I appreciate the circumstance that she's in, and
cases like this aren't just about alcohol or device tampering. They're about accountability. Life might be throwing Miss Brown every curveball imaginable.
I do have in the next week before the first medical alcohol treatment with another drug testing per bond order. And I also have general therapy with my counselor, my therapist, all of those appointments, as well as some medical appointments for the 1st of August. I have not left the state, and I was here this morning. Was not able to get here to turn myself in, but I was here for this hearing, and I can assure you I'll be here on the 1st. I really need to make these appointments.
You shouldn't have had to go through whatever. And like I said, it's not like you didn't get the information from your attorney. You didn't get that. I'm reading everything she's sending me. She's doing a yeoman's job trying to represent you and do that. You're just not following through.
I do not have a license, and I'm really sorry that I was not.
But court doesn't stop for that. If you're in violation, your intentions don't matter as much as your actions. That's the tough truth she's learning right now.
She said she'd meet me at 1:45, and I texted her at 1 o'clock and said I'd be here at 1:30 and that I would meet her at 1:45. I didn't ask her for a ride, though. You're right.
She did text me. It was after the morning, I want to say noon, that you were not able to turn yourself in this morning and that you would be here at 1:30. So I said that to meet me here since you were going to be meeting me here. So.
How'd you get here this time?
I had a friend of mine picked me up.
I think that what you want to do is you don't do what you don't want to do. And then everybody is sort of just misled as to what you're going to do. Well, it doesn't work that way. Because it puts a whole lot of people out. Because like I said, we're going on Miss Julian's representation of what you what she instructed you to do and what you said you were going to do. And you didn't do it. And then everybody's looking around. We don't even know where you are or that you're going to show up at this time. You don't get to make those choices. So at this time, and Ms. Julian, you can file a motion regarding her additional appointments and other things that she may have to do. But at this time, defendant's bond is revoked. Defendant's